Hi, my name's Elizabeth and I'm the owner at Life Law Solutions. Today I'm talking to you about some key principles in family law matters, particularly parenting matters. These are terms that you will come across when you're going through your family law journey, and it's important to understand just what they mean. One of the most important things is to understand that a court, in determining what parenting matters are going to be in place for a child, must have regard to ensuring that a child has a meaningful relationship with both parents. This has to be balanced, of course, with making sure that children are protected from harm. Harm can be abuse, neglect, or family violence. So long as it's safe to do so, protecting and providing a meaningful relationship between the children and parents is one of the most important features of the Family Law Act. Another key principle, and in fact the paramount principle, is ensuring that the children's best interests are met. A court must always be guided by the best interests of the children. There's a section in the Family Law Act, section 60cc, which sets out what factors guide a court, lawyers and parties in determining what are in the children's best interests. Some of these things include any views of the children, the nature of the child's relationship with each of the parents or other family members, whether a parent is involved in decision making or taking up opportunities to spend time or communicate with children, the capacity for parents to provide for children, whether there's been family violence, and a whole lot of other factors. What about equal shared parental responsibility? Is it the same as equal time? This is often a question that we get asked. Equal shared parental responsibility refers to how parents make decisions for their children. These decisions are called major long-term decisions. They're not day-to-day things like whether there's a sniffly nose for a child. Major long-term issues include education and schooling, religion and cultural matters, major health decisions, the child's name, and changes to the parenting arrangements for a child, which make it significantly more difficult for a parent to spend time with that child. It's very different to equal time, and it purely relates to decision making. So when does equal time come into play? The next most important section to consider sets out the framework for how a court, lawyers and parties work out what arrangements are going to be put in place for children. The law says if parents agree or if the court orders that there's equal shared parental responsibility, then the court first needs to consider whether equal time would be appropriate for the children. For it to be appropriate, it must be in the children's best interests and it must be reasonably practicable. That is, there needs to be similar arrangements for parents between households. They need to live reasonably proximate to each other, and they need to be able to communicate for that to work effectively. If it's not in the children's best interests or reasonably practical, then the court considers what's called significant or substantial time. This is something less than equal time, but it includes weekend time, weekday time, and special arrangements, special days. If significant and substantial time is not in the best interests of a child, or again, reasonably practical, then the court has to think about what other options are open and what other arrangements can be put in place for those children to spend time with that parent. I hope this has been helpful for you. If you need any more information, you can find that on our website, or book an appointment to see one of our family lawyers so that we can talk to you about your circumstances in more detail. Thank you.